Nako olwaleero ffe nga bannakawempe tuli basanyufu olw'okuba nti kkooti enkulu egobye omusango ogw'ebyokulonda ogwali gwawabira mwami Ssegirinya, gwawabira mwami Kidandala nga wabira Ssegirinya oba nga wakanya okulondebwa kwa Ssegirinya. Ffe tulaba nti twongedde okulaba nti kkooti ddala ziyimiridde ku musingi gw'amateeka era mazima na bwenkanya, olw'ensonga nti omuntu toyinza kubuzaabuza kkooti nti omuntu eyakwatibwa nga musibe yakulema okusaavinga, ate gwe muntu omu n'osaba kkooti ekukkiriza omusaavinga ekuwe n'ensaavinga n'ebikuwa byonna court orders n'olemerera okukola kyo bituukiriza. Ffe tulowooza nti olunaku olw'olwo bannakawempe twagala banywera emitima era tuli basanyufu olw'ensala ya kkooti, ate era twagala n'okugumya Honorable Ssegirinya tina emisango gino egimu gyetekebwako kugeza ng'egy'ebijambiya ffe tukimanyi byonna bigendereddwa lwa bya bufuzi era ensonga lwaki mubala abaline mu kwapiringa era temwewuunya okulaba abantu bebamu nga bebawa obujulizi mu misango gy'e Masaka. So ffe tuli basanyufu era tujja genda maaso n'okulabika nti tuyimira wamu n'omubaka kuba kye tusinga okwetaaga selection petition wabula twetaaga buweereza mu Kawempe North.
So this is the ruling. On January 14, 2021, parliamentary elections were held nationwide. The results of the election for members of parliament for Kawempe North constituency were as follows. Ssegirinya Muhammad polled 41,197 votes, while Serwada Sulaiman Kidandala polled 7,212 votes, making Ssegirinya Muhammad the duly elected member of parliament for Kawempe North constituency. On March 18, 2021, the petitioner, who is also the respondent in this application, filed election petition number 5 of 2021 against Ssegirinya Muhammad as first respondent and Electoral Commission as second respondent, in which he challenged the academic qualifications of Ssegirinya Muhammad and sought an order nullifying the results and declaring him, that is Serwada, as the duly elected member of parliament. The court record of election petition number 5 of 2021 shows that while the second respondent, that's the Electoral Commission, filed an answer to the petition on April 6, 2021, the first respondent, that is Ssegirinya Muhammad, did not. On March 23, 2021, Serwada filed miscellaneous application number 226 of 2021 for an order of substituted service and for an order to serve Ssegirinya Muhammad through the officer in charge, Kidandala prison. My brother Judge Baguma J. ordered service of the petition in the following terms: that the respondent, that is Ssegirinya, be served with notice of presentation of the petition through the officer in charge of Kidandala prison, and the officer in charge should witness personal service of the respondent. That was the order. The Registrar of Civil Division posts a copy of the presentation of the petition on the court's notice board. That was the second point. MA number 557 of 2021. In this application, Electoral Commission sought an order under Section 33 of the Judicature Act, Rule 17 of the Parliamentary Election Rules and the Civil Procedure Rules, that election petition number 5 of 2021 be dismissed for non-service of the petition. In support of this application, Electoral Commission relied on affidavit of Mugia Felix, OC Kidandala Government Prison, who denied service on Ssegirinya and denied witnessing the said service. In response, the respondent, that is Serwada, filed an affidavit in reply in which he opposed the application to dismiss the petition and deponed that the Electoral Commission had no locus standi to bring the application, that the application is misconceived and raises issues of review. The application is supported by an affidavit without authority from the applicant, that is the Electoral Commission, that the application is a vessel for blackmail, an abuse of process, and a corrupt endeavor against the respondent. Furthermore, that Ssegirinya was served by the process server on March 23, 2021 at the Central Police Station, Kampala, and on April 1st, 2021 at Kidandala prison by process server Kato Fred. Counsel Alaka and Muyizi for the respondent, Serwada, and Counsel Alaka and Muizi for the respondent, Serwada and Counsel Sabiti for the applicant made oral submissions that I have carefully considered. I note that Counsel Alaka argued only their response that Ssegirinya was served at Kitalia prison by cut-off raid on April 1st, 2021. I shall therefore take it that Counsel abandoned all other responses contained in the affidavit in reply of Serwada produced above. The issue for determination, therefore, is whether electoral petition number 5 of 2021 was served in accordance with the law and in compliance with the order of my brother judge issued on March 29, 2021. As rightly submitted by Counsel Sabiti, my brother judge Baguma J ordered service through the officer in charge Kitalia prison, and the said OC was required to witness personal service on the respondent, Ssegirinya, who was in prison custody at the time. Rule 6, Sub-Rule 3 of the Parliamentary Election Rules stipulates that service of the petitioner shall be personal, while Rule 6.5 permits the court to direct service by substituted service under Order 5 of the Civil Procedure Rules. Counsel Muizi for Serwada submitted that the modes of service under the CPR do not apply to modes of service under the Parliamentary Elections Act and the rules, citing High Court Civil Suit number 362 of 2013, Jolly Tumuhimbise versus Jolly Otage, in support, where Madrama J, as he then was, made a distinction between good service and effective service, and does not discuss applicability of Order 5 to service of process in election petitions. I failed to see the relevance of the precedent to the issue before me, so I shall not dwell on it. Suffice it to say that the concept of personal service on a respondent is no different from the concept envisaged in Order 5, Rule 10, which is that, I quote, wherever it is practicable, service shall be made as much as possible on the defendant in person, unless he or she has an agent empowered to accept service, in which case service on the agent shall be sufficient. The point I'm driving at is that the order of my brother judge did not depart from the requirement in Rule 17 of the rules for service to be personal. Furthermore, cognizant that the person to be served was a prisoner, the court directed service through the officer in charge of Kitalia prison, where the person was held and the officer was to witness the service. The evidence in the affidavit of service that would prove service on the officer in charge is his or her written endorsement on the petition that he or she has received the summons. The fact that the officer in charge, Mugia Felix, has denied witnessing service on the petitioner makes it even more imperative that the only proof of service on him would have been his signature. Unfortunately, the evidence of service is the word of the process server against the denial by the officer in charge of any service. In the context of the order of my brother judge, witnessing service meant the officer in charge had to endorse the petition, and if he declines to do so, the process server was to report accordingly in the affidavit of service. Black's Law Dictionary 9th edition refers to such a witness as an attesting witness, one who vouches for the authenticity of another's instrument that the other has signed. In this case, the officer in charge could be attesting that the prisoner in his custody has been served. An examination of the affidavit of service of cut-off Fred shows that his focus was on the respondent in the petition, and at no point did he mention an attempt to require the OC to endorse the petition and stamp it with the official stamp as duly served. Service on the officer in charge could have been construed as effective service even if the respondent had declined to accept service. This means that even if the process server did visit the prison, he did not effect service in the manner ordered by the court. The other aspect of this issue of service was whether the order to pin the petition on the notice board of the Civil Division was sufficient to constitute service. I find that the order to serve the respondent personally and the order to pin the petition on the notice board had to be effected concurrently, and non-implementation of one meant the service was ineffective. In summary, having found that the officer in charge did not endorse the notice of presentation of the petition, there was ineffective service. The Court of Appeal in Election Petition number 62 of 2016, Dionisia Sisi and another versus Martin Serwanga, pronounced that restrictions under Section 60, subsection 2B of the Parliamentary Elections Act on requirements of a petitioner who petitions as a registered voter to attach a list of 500 signatures of registered voters should not be taken lightly. Applying the principle to the instant case, it goes against the strict application of the special procedures under the Act for me to extend time for service of petition. Having found that service was ineffective, I also rely on a recent decision of my brother Judge Bashaija J in MA number 179 of 2021, arising from election petition number 2 of 2021, Wanyoto Lydia Mutende versus Electoral Commission and Nakayenze Galiwango, where the court declined to grant leave to amend the petition for the reason that the court has no residual powers to extend time for filing a petition. In the premises, the petition is rendered redundant for non-service and is struck off the record. For the reason that the petition was a non-starter, each party shall bear their own costs of this application, that is MA 557 of 2021, that is the EC versus Kidandala, MA 596 of 2021, Serwada versus EC and two others, and election petition number 5 of 2021, Serwada versus Ssegirinya Muhammad and Electoral Commission.
So kyekibaddewo ndi musanyufu kati ndowooza n'ab'ekawempe basanyufu kubanga tuwali petition n'abagigobye. Weero kibaddewo nti okusaba kwaffe omulamuzi akukkiriza n'akkiriza n'okusaba kwange n'agamba nti petition ati ya servinga bulungi kubanga koti yamuwa order n'emulagira engeri y'okuservingamu ye yakyusa n'akola bibye kubanga koti bwegamba nti servinga mu ngeri eno tolina okuservinga mu ndere engala. So bwe nakiraba ku record ngange ngo lawyer w'akakiiko ningamba sisobola kubeera musango nga waliwo ensobe ningenda koti katekkiriza nange negamba nti order gye wawa petitioner yagikyusa n'aservinga ebirala bibye kubanga bamugamba serving oli personal ng'oli alina okuyitirisinga omuservinga ye n'agenda mu bye loze agenda kukyalira abagundi abasuspect nga tamanyi court process. So court egambya zino matters ziri serious. The matters ziri serious. Court bwegamba servinga mu ngeri eno olina okuservinga mu ngeri eyo.
Omulamuzi awadde ensala ye n'agamba nti election petition number 5 of 2021 tetwagiservinga bulungi nti mu kifo ky'ogiwa owa poliisi twagiwamu wawaabirwa. Bw'atyo bw'agambye ntwalina okuwa owa prison so si omuwawaabirwa. N'agamba nti awo tetwaservinga bulungi. Tufunye instructions okuva wa client waffe ogenda mu Court of Appeal, era kati tugenze mu Court of Appeal. Natugamba nti tulina affidavit of service emala, tetwetaaga genda kitali ekiriwo kimala, n'ate kyatunuddemu n'agamba nti tekimala. Simanyi mu Luganda bwe bayita bino ebya amasimu agalaga nti otuuse ekitali. Tulina ekitabo mwe twasayininga ekitali, omulamuzi kyeyagamba tekikyetaagisa. Tulina obujulizi obw'omuntu eyaservinga. Ate nga service yeyo yokka ne ku police twaservinga emirundi 3. Ate nga ne ku kooti y'eggwanga kukyaliko petition eyo kati wenjogerera as another way of serving. Naye omulamuzi ye mulamuzi eyo ensalawo ye tetwagala kusukkaawo, naye katugendeko mu kooti esingakaawo tulabe kiki n'agamba.